Wait, item 5.
5.
Yes, maybe for 4 weeks because I have not taken the step to have
You
the
take-
press. I have to take the press statement.
Press steps.
Yes.
One name has been reflected for either appearing for respondent number 1 or whom I mean.
Your Lordship, in this case, one of the victim was impleaded actually, and for the other one, the counsel is appearing. But for the father of one of the victim has been impleaded, since deceased victim has been deceased victim, so steps in favor of him has not been taken. But
Or that he or she is represented as respondent number 2.
yes, Your Lordship.
Impleaded.
There is total state is the one first
Yes.
party, then second and third. Second is appearing. Third is the newly impleaded party.
So you have not taken steps.
No.
Magistrate is on the land counsel for the petition and also had the land additional PPF on the state respondent number 1. And submitted by the land counsel for the petitioner that he has not taken steps to newly implemented respondent number 3. And accordingly sought for some of them. The petitioner will accordingly take it.
Your Lordship, respondent number 4, Your Lordship.
Is 4.
3, yes,
But
respondent number
2 is 3.
2 is appearing,
Yes.
Government.
and 3 is Your Lordship, the headmaster. He's not appearing.
But service is already completed.
Yes.
On 3.
3 is not at all required because 3 is a school teacher, Your Lordship.
No, whatever.
Yes.
Service is completed or is not.
Service is not complete in this against respondent number 3 also, Your Lordship, perhaps, Your Lordship.
Then 3 and 4 are fine.
4 is newly impleaded party, Your Lordship. Respondent number 4.
But you have taken steps.
Earlier taken, but it was not properly served. I'll take both the parties, madam.
And what about the respondent number 3 is already served or not yet served?
No, sir. Your Lordship. 4 is newly impleaded, not newly, long time back, but on last occasion, perhaps on 18/11/22, Your Lordship, there is a direction to petitioner to take steps upon respondent number 4. That is the father of the deceased person, Your Lordship. Respondent number 2 is the victim girl, Your Lordship.
So you take fresh steps for both
Yes.
3 and 4.
Yes, ma'am.
If 3 is not
Yes.
required by somehow, then you can edit his name also subsequently.
Yes.
But this time you take steps for 3. According to the petitioners, you have been asked to take fresh steps on respondent number 3 and 4. This time you want to register post or it will be it's a criminal
Both
matter?
the ways, both the ways.
Both the ways.
Yes.
Register
will
post
better.
and through jurisdiction and police station. OC of the concerned police station. Both the ways you take.
Yeah. Obliged, ma'am.
List after 4 weeks.
Obliged, Your Lordship.
My Lordship, Lordship, I like to mention item number 18, Lordship. Matter may be listed after 1 week, Lordship.
1/8.
Yes, Lordship.
The request of so is the matter of program. As she has received paperwork is also ready. Paperwork is ready on it.
And Lordship, item number 2, Lordship.
Hmm.
This matter also listed after 1 week, Lordship.
The request of so is the matter of program.
Also, interim order is there, Lordship.
Interim was there.
Yes,
Instead we continue till next.
of life.
My lord, I beg to mention item number 6.
Hmm.
My lord, I on behalf of the respondent, sole respondent,
Hmm.
and consent has been taken from other side.
Hmm.
Matter may be listed after 3 weeks.
With the consent of the other side, the learned counsel appearing on behalf of the sole respondent. made a prayer for adjournment. List the matter accordingly. Otherwise, why it is in order column? Is there any issue regarding the service of notice and etc.?
No, my lord.
Service is already completed.
Already
It
issued.
is sole respondent only.
Yes, ma'am. My lord,
State
I
is not
beg,
there. State is not there.
state is not there. My lord, I also beg to mention item number 19.
No, wait. Item number 6, I'm asking you. Order item number 6, it is in order column. Why it is in order column?
My lord,
If otherwise case is ready,
actually, my lord, I am on instruction, so I have no idea.
list accordingly. After 2 weeks. And another item,
Another item, my lord, item number 19. My lord, here, respondent, standing counsel, Mr. T. Tango is out of station. So consent from other side
consent
also
with the
taken.
other side.
Yes. my lord.
And your good
My
name,
my
Your
lord, this
name?
matter may be listed after 3 weeks also.
your name,
T. Mite, my lord.
T Mite,
Yes, my lord.
or Mr. T Mite appearing on behalf of Mr. T Tago, the learned counsel or the respondent. Submitted that this engaged counsel is out of station and accordingly with the consent of the other side, he paid for an action. The matter be accordingly listed after 3 weeks.
Yes. Much obliged.
May I, my lord? My lord, I beg to mention item number 11 and 12, my lord. I am for the petitioner. So leading counsel is abroad India. He may be take time to return. So kindly matter may be list after 6 weeks, my lord.
Leading counsel is
Abroad India, my lord.
abroad,
Yes, my lord.
list after 6 weeks. On the request of students, list after, you are for respond, you are for.
I'm for petitioner, my lord.
For the petitioner.
Yes, my lord.
On the request of learned counsel appearing on behalf of Mr. On behalf of the appellant, let the matter be accordingly listed after 6.
Obliged, my lord.
Yes.
May I, Your Honor? I'd like to mention item number 13 on behalf of Mr. Tapatagum. The parties in this case all are relatives to each other, so they are trying to settle the matter outside the court.
They
So,
have already settled.
pardon, Your Honor?
They have already settled the matter.
No, it's not settled. They are trying to settle. So this matter may be listed after 8 weeks.
After
8 weeks. 8 weeks.
there are instances for listing the matter after 8 weeks. Can be. No. He is seeking 8 weeks time. That can be given. You are Mr.
Hagetai, H. Tai.
H. Time,
Yes, Your Honor.
appearing on behalf of whom?
Appellant.
Appellant, or Mr. H. Time appearing on behalf of the appellant, and this submitted that the stock of compromise is going between the parties. And there is probability of amicable settlement between the parties, and hence and for which some more time is required, and accordingly paid 8 weeks time for the 8 weeks time listing the 8 weeks time accordingly. List the matter accordingly after 8 weeks.
Obliged, Your Honor. May I please, Your Lordship? Your Lordship, we have filed a criminal petition for quashing of an FIR. So matter may be listed today, Your Lordship. It's a prayer.
It cannot be, I have a meeting. Tomorrow it can be. It can be listed only tomorrow. Tomorrow.
Okay, may, like Your Lordship. Your Lordship, may I mention item number 17? Can it be listed after 3 weeks of consent of the petition?
What is the ground?
This is for sub hearing now.
Yes.
It's a DB matter.
It
Because-
should be a DV matter.
Yeah,
Huh?
a domestic violence.
No, let 17 record of 17 days. What do you say? It's a DV matter.
Arising out of domestic violence.
Huh?
Domestic violence.
Domestic violence is DV.
My lord, the arising out of so,
But it is a revision petition only.
And this, yes, this is a second revision. Pardon, my lord. Yes, my lord.
Second revision.
Yes. My lord.
Actually, there should be an appeal preferred by you before session judge. But that was not done.
Not
It
done.
was most probably revision was filed.
Filed,
Revision is not live before the session judge. It is only the and the 29th. This should be an appeal. So that point was raised, I think, in order to 28/1/2020. There is some observation by this court. But you have not raised this matter that it should be placed before the division bench. You have not raised this issue earlier.
No.
Why? Why you remain silent?
Lord, I think I have made a specific error clarifying the mentality of patient. What did my lord? There is statutory appeal, my lord, under the DBA, my lord, before the session court, my lord. But what, my lord, I considered, my lord, instead of doing so, my lord, I filed the appeal, my lord. Oh, sorry, my lord, revision, my lord. Now, even if my lord, even if it is revision, my lord, the session court otherwise has a jurisdiction under as a appellate court, my lord. Accordingly, my lord, even if this is the nomenclature, my lord, is mentioned as a revision, my lord. But from against the appeal, my lord, this revision, my lord, will be maintainable, my lord. I have clarified that issue, my lord, in my petition, my lord. A specific amendment has been made, my lord.
I'm on that. Why you have not raised the issue?
My lord.
Because the case is pending since 2018.
Yes, my
If
lord.
it is a matter of DB matter, then why? It is, you are, as per you, it is a division bench. It should be-
No, my we are saying, my lord, this case arising out of a domestic violence case, my lord. Now, my lord, what happened, my lord, I have a clear categorical instruction, my lord. In this case, my lord, his client and my client, my lord, got remarried, my lord. But
Oh, acha.
the situation is dead, my lord. Now, as my lord, he is unable to take proper instruction from his client, my lord. We are praying for some time, my lord. Otherwise, I have a categorical instruction, my lord. My client and his client, after divorce, got into remarriage, my lord. So that's the present situation.
Remarried.
Yes, my lord, present situation.
But Mr. Alpami, you are for the petition.
Yes, my lord.
Heard Mr. Alpami denied counsel for the petition. I also heard Mr. DK Devi denied counsel appealing on behalf of the respondent. It is submitted to learned counsel for both sides that after the divorce, both the parties got remarried, and there is a probability of amicable settlement outside the court, and hence to take sought some more time to take instructions for the respective parties. They are allowed, let the matter be accordingly listed. How many weeks or after 3 weeks? 3 weeks. 3 weeks. Let the matter be listed after 3 weeks.
Always.
I was misconceived. I thought that you are saying they should be
domestic
paid.
violence.
That's what I am saying. Why it should be paid?
It's a domestic violence.
You are saying DV. I thought that
Oh.
your prepare submission is there. It should be paid before now.
Sorry.
May please, Your Honor, I beg to mention item number 7.
7.
The service is still not completed in respondent number 2. It may be taken up after 3 weeks.
So and so it submitted the service is not yet completed on this one number 3. You want to take fresh steps?
Yes, ma'am. Through dusty service as well. Your Honor, earlier also dusty service was allowed, but we could not contact the.
Okay, then we will allowed to take the steps to justice service as well as the petitioner is asked to take issue notice to the respondent through OC of the concerned police station. Take both ways. List up to 4 weeks. Through concerned police station, OC of the concerned police station also.
Stabilized.
Yes.
My lord, this motion item number 20 and 21. my lord.
20
It's,
and 21 are.
Yes, my
of
lord,
same.
it's the same, my lord, arising out of the same FIR. my lord.
fire.
My lord, brief facts, my lord. In fact, what happened is,
Who is representing the state? Who is appearing for the state?
Yes, additional BP attached appearing. File is became, I want
Just inform. Okay, yes.
excuse me. My lord, last year, on 3rd of September 2022, my lord,
Hmm.
the alleged victim in this present FIR, my lord. Last year, what happened during, due to some small misunderstanding, my lord, that person, one Samdev Bakim, he assaulted my father, my lord, with a dowel, where my father was seriously injured, my lord. And treatment was done, but due to some tendon injury, now my father is around more than 60 years old, my lord. Due to tendon injury, his right finger, right hand is now permanently, my lord, disfigured, my lord. That treatment was done, and if my lord will come to page 10 of my application, ma'am. Page 10, yes, ma'am. Annexure 1, ma'am. Of course, this is written by the. It's difficult to understand the handwriting of the doctor, but next page I have given the type copy, my lord. Diagnosis: lacerated wound at head. Suppose head. It's not head, my lord. It should be hand, my lord, with tendon injury, man. So that happened, man. And in that case, my lord, the police investigated and eventually charge-sheeted, my lord, the victim in this present FIR, man. Now, after the charge sheet, my lord, the trial summons was issued by the additional district judge, my lord. Under in the charge sheet, the person was charge sheeted under section 307, my lord, in that case, man. Now, when the trial summons was received by that person, man, the accused person, to appear before the additional district judge, it was fixed on 24th of 7, my lord, last month, or this month, my lord. Now, when he received the summons, my lord, he then again came and assaulted in this instant applicant, man, in item 20, man. In fact, he was trying to assault his father, who is the complainant victim in the earlier case, man, in last year, man. Now, when he could not find the father, man, he assaulted me, man. If you also would see the next page, my lord, is page 12, my lord, annexure 2, my lord. On 24th of June, my lord, I was assaulted, man. So what happened, my lord? He ambushed and assaulted me. He cut me on my backside, my lord, with a dowel, man. And upon learning that it's in the vicinity, my parents and my brother, when my father came to learn about it, he went to the house of the person, my lord, to inquire. There a minor scuffle took place, but nothing major happened. And then after that, my father and my brother, they took me to the district hospital, Dabruja. It's around 2-3 hours journey, man. And this is, my lord, the emergency treatment that was done, my lord. It's assault, lacerated wound, my lord. So and so in the back, my lord. After that, on next day, my lord, I left for Itanagar for further treatment. And when we came here, my lord, after when the treatment was going on, then we came to learn that the daughter of the supposed victim has filed an FIR, my lord. It is at next page, my lord. Page 13, my lord. To the officer in charge police station, Talia, my lord. FIR against Dozen Eru, my lord. He is my father and who is the victim in the earlier case, my lord. Gentu Eru is the applicant here, my lord. And Jenda Geru is my brother, my lord. In applicant in item 21. Now, accordingly, after this, my lord, a case has been registered, my lord, at Talia PS case number 4 of 2023, my lord. And since we were at the Approach hospital, my lord, on that day, my lord, and on the next day, my lord, this was lost, man. And there's a counter complaint also, man, against this person, man, that one Samdev Baki, my lord. His daughter has filed this.
That means, this is the subsequent FIR against you. Earlier, it was an FIR where the 307 was registered and the allegedly the hand of one so and so
Like,
also been amputated.
No, not against me, man. This person, my lord, here the victim, my lord, the supposed victim, my lord, who is, my lord, is the accused in that case, man.
In
Last
earlier
year,
case.
yes, earlier case, my lord. Earlier case, last year, my lord, my father was assaulted. This year, my lord, I have been assaulted by the same person.
The victim is who? Miss Naam Baki is who?
Victim daughter, she is the daughter, my
She
lord.
is the doctor.
Yes, my lord. Daughter has filed a FIR, my lord, before the police, Talia police station, my lord. And his father, her father, is the same person who assaulted my father last year with a dog. And this year also, my lord, he again assaulted me after receiving the summons from the additional district judge. It's the same person who's assaulting my family, man. Last year he assaulted my father. My father is more than 60 years old, man. He's now suffering, my lord. Right hand, it doesn't function, my lord. And now he has assaulted me also.
So now this time they finally lodged in FIR against you.
Yes, my lord. Against me and my father, my lord. Now, as I've said, my lord, on the 24th of June, my lord, when I was assaulted, my lord, I somehow managed to escape, my lord, with a cut, my lord. And after hearing about the incident, my father, of course, went there. He is old. He is not in a position to fight, my lord. He went to inquire about the incident with the person, man. There, a minor scuffle took place, nothing serious. And after that, my father and my brother took me to the hospital, district hospital. And in the meantime, this complaint has been lodged by the daughter of the person who assaulted us, man. And on the next page, my lord, this we have again lodged FIR against the same person. Man. Last year, he assaulted my father. That there we have all mentioned, my lord. Now the daughter of that person, he says, the victim, supposed victim, he says that she says that I and my family, we have taken revenge for last year, man. That is, they have basically allegation, man. But otherwise, our FIR is also there, and our case has been registered as Talia PS case number 5 of 2023, my lord. We have also filed something. But difficulty is since we came here, after that we learned to learn about the FIR. Now we want to cooperate, my lord. We want to go back home, my lord, and because both the cases, in our case, nothing has been done, my lord, because victim and everybody is here for a treatment, my lord. And in other case, all other witnesses have been examined other than this accused person. We want to cooperate now. We want to go back and then we want to, but the only option is that we might be arrested now. Whereas I am the victim, I have been assaulted. Last year, the same person assaulted my father now. So my at this case, my CD may be called for and then my lord grant some interim order, my lord. We want to go and appear before the IO also, my lord. We want to depose or give a statement in the case filed against that person also, in both the cases, my lord. And item 21, item 21, my lord, he's my brother, my lord, who is a 19 years old student, my lord. Second year
So
BA.
the case is not filed against you and your father.
Me,
It's filed against you and your brother.
no, against my father also, man.
So for father, you are not appearing to.
Father, my lord, as of now, he has not come. He is not a position to travel, man. So the brother and since they are already here in the Itanagar, man, these two persons, they came here for treatment. In item 21, my brother, this applicant is a 19-year-old student, man, BA portion, second year is doing that. At this stage, I will say that the CD we call for, my lord, grant some interim protection. We will go back and then we'll cooperate, man. We want to give our statement in both the cases, man. Talia cases 4 and 5 both, man.
Yes, may it please your lordship. Your lordship, at this stage, it can be presumed that there exists an enmity between them, your lordship, because it's a counter attack. Earlier, they have their father has been attacked, and now at this present stage, after so many days, when the charge sheet has been filed, they again take revenge from the other side, your lordship. And the allegation, your lordship, allegation is serious, your lordship, is 307 attempt to murder. And no doubt, your lordship, the section 325 is available, your lordship. But your lordship, when 307 comes, your lordship, the nature of injury is not condition precedent, it's the intention. So what my humble prayer before your lordship is, your lordship, let the CD be called for. And after your lordship perusing the CD, your lordship may consider.
My lord will just go through the FIR once, my lord. It doesn't say anything, although it says attempt to murder, my lord. But nothing is there, my lord. Only saying that we are trying to take revenge, my lord. Whether any weapon is being used, nothing is there. And my father is, my lord, due to the attack last year, my lord, he's basically handicapped. He cannot use it right hand now. Tendon injuries, permanent. My lord, I will just pray for interim protection, my lord. We want to cooperate, my lord. Yes, Lord. Till the CD comes.
Heard Mr. D. Suku, the learned counsel for the petition, and also heard Mr. D. Suku, the learned additional people appearing on the Mr. D. Suku. This is an application under section so and so, the connection with. It is submitted by the learned counsel for the petitioner that on 3/9/2022, the one as Bucky, the informant, the victim in the present case, in the instant case, approached the father of the petitioner and he attacked his father with a mechi dao, sustaining a serious injury on his person, and subsequently one right hand or left hand, right hand of his father was also there was intended injury on the right hand of his father, and for which they already lodged an FIR which was registered on section 447 324 by 307 IPC, and subsequently it was charged sheeted.
Charge sheeted, madam.
Charge sheeted,
Trial,
and trial is also pending before. Trial is pending before additional session judge.
recent session just Basar. madam.
Additional session judge Basar. But on and when you attack on the same date, 24/6/2023.
24/6/2023. madam. I was assaulted after he received the summons from the court, madam. After this, yes, he received the summons from.
After receiving the summons from the additional session judge, the present the victim of the present case assaulted the petitioner on 24/6/2023 while returning home, and thereafter he also attacked his father. Your brother was not attacked.
No, my lord. I was
The father was also attacked his father, and thereafter the said victim ambushed and attacked with a mechi dao and cut the present petitioner on the backside of the head. But somehow he managed to escape, and thereafter when his father and his brother rushed to the spot, hearing the assault, hearing about the assault on the applicant, there was a scuffle between the parties, but with some false and concocted allegation, the FIR has been lodged against him, which is already registered in the
Taliha, my lord.
Taliha police station. But no such incident had happened, which is been described in the FIR, except a scuffle between the parties. The present petitioner has no involvement in the alleged offense, as he was assaulted and he sustained injury in the said incident. However, after the said incident, the present petitioner, you have lost or your father has lost it?
No, my uncle, madam. We were at hospital, my lord.
The uncle of the petitioner lost an counter FIR, an FIR with counter allegation, and as the present petitioner along with his father were in hospital. It is submitted further that both the
It has been registered as Talia PS case number 5.
also been registered the Taliha police station.
Yes, ma'am.
Taliha police station under section 30 Your petition is also registered under section 447-307.
Yes, my lord.
Section 447-307, 325/34 IPC. Full stop. The present petitioner is innocent and he is no way involved in the alleged offense. However, he is ready to cooperate in the investigation of this case if he is granted with some interim protection, so contact protection. Accordingly, submitted that granted with some interim protection. Full stop. In this context, the learned additional PP, Mr. Ekate, has submitted that, and from the FIR and counter FIR, it seems that there is an enmity between the parties, and more so the section and more so the FIR has been registered under section 307 IPC, which is a serious offense, and hence the perusal of the CD is necessary before passing any order in bail. Considering this submission made by the counsel for both sides and enter aspects of the case, I find it difficult case to extend the privilege of interim pre-arrest bail till receipt of the CD, following conditions that will go with 20,000 rupees. And the next one is 21, is almost same. But
Same.
Here this is a brother, so he did not sustain any injury. It was a scuffle and all, you can write all this. Almost same, but he did not sustain any injury. That part that has to be omitted. So
Yes,
you
sir.
are granted with the interim protection, list the matter for call for the CD, list accordingly for
9th or 10th, my lord, of August.
9th August, your lordship.
9th.
Maybe
9th of August.
9th of August.
Deeply
9th.
obliged.
Obliged, your lordship.
It's 22.
May I please lordship? Lordship, this is a criminal petition for quashing of SEPA PS case number 06 of 23. So lordship, may I take a fire first? Lordship, page number 15. This is the FIR on the basis of which a case has been registered.
Page number?
Page number 15 of my petition,
15.
lordship. Yes, this is a typed copy. Lordship, may I read? Lordship, while inviting reference to the subject cited above, I would like to apprise you that my wife, Srimati so-and-so, is avoiding me for simple reason of both argument with her during through mobile phone on 20th January 2023. Since then, she's stopped talking to me and I didn't talk to her forcibly. I smell some foul play behind it. It had recently come to my knowledge that one Sri so-and-so and my wife had been in illicit relations, living relationship with since 2020, January 23 to till date. Both of them intended to marry each other in future, so my wife so-and-so is forcing me to divorce, meeting immediately with her. With this fact were revealed from the dirty chat they have exchanged in each other on WhatsApp and Facebook messages found from the mobile hands of Sri so-and-so. When my three younger brother picked him for interrogation and inquiry from Ganga Market, Itanagar, Sri so-and-so was supporting financially and regularly transferred money to my wife's account and furtherance of their illicit physical relationship and planning eliminate me from their way.
This
So-
is registered under which section? Actually?
Yes, lordship, exactly. So this is the FIR on the basis of which I have been issued summons to appear tomorrow. It is on 28, 27/23. So lordship, purportedly the FIR is registered but without any section. And from entire reading of this FIR, no cognizable offense has been disclosed. No, so yes, exactly how police can take is that. Moreover, lordship, my petitioner husband is a very rich and influential person. He is the executive engineer in the Department of Power. And under his influence, this respondent number 2 has registered this FIR, but since he couldn't find any section attracted to this alleged offense, so he has not put any. So illegally and arbitrarily they are initiating these actions to compel me to appear before them. So my humble submission before this honorable court is that this matter may be admit and call for the records until then operation of this summon dated 21/7 may be stayed.
Lordship,
Because
here,
no-
Lordship
because
is
not-
FIR, Lordship. It appears that it has not been registered. It is as a FIR, and here Lordship may go to page number 18, Lordship. Here it is status of the case under investigation. Maybe just they have received the FIR, but it's not been registered yet. And the process may the police can Lordship, they can call, and for the investigation purpose they can call. It doesn't mean that she will get arrested, Lordship.
Because FIR is
Yes,
not
Lordship,
registered.
my,
Yes,
my,
yes,
my
Lordship.
humble submission is
It's only for
that,
preliminary inquiry, Lordship.
yes, police cannot even conduct preliminary inquiry in this such case because it is a moral wrong, and moral wrong doesn't attract penal provision. And moreover, if, yes, Lordship, if go by the face value of this
Lordship,
FIR,
One
Uh,
allegation is also there regarding the mosquito trapping and all are there. I think.
Lordship.
And maybe registered, I don't know in what section.
Lordship,
here.
because this is only Lordship.
Do one thing,
Lordship,
You can take instruction, then just
Yes.
submit the report.
yes,
Okay.
Lordship till then, yeah, Lordship till then in interim.
The case is not yet registered. what
Yes,
is
in fact,
Because
Lordship, may I submit it? Lordship, police cannot inquire at all. Because if, as for the, if we go,
For
Lordship may
registering a
kindly, because
Before registering a case, police has the authority to go into.
no, Lordship, in such a case, police cannot, Lordship. Police cannot, if, yes, if we go by the face value, at the most, the police can refer the matter to the magistrate.
If there is no case in the face value of the FIR, then it's so free.
Yes.
Lordship,
You just take the instruction and submit the, ask IO to submit the report
Lordship,
immediately within 2-3 days.
Lordship,
So that it can by Monday or
Lordship.
can it?
Lordship,
be-
if
Not
FIR
like
is-
tomorrow,
yes.
must be by Monday.
Lordship, may, then tomorrow,
Then-
because I've been directed to appear before the police by tomorrow. And Lordship, it's
Tomorrow I
very
cannot say
clearly,
Tomorrow will be possible?
No, Lordship,
because over the phone, Lordship, it's very easy, and Lordship, it's clearly written that if you neglect and ignore the police
Lordship,
summons,
I'll
action
try
may be
to Lordship-
initiated under appropriate provision. So in any case, police cannot initiate this kind of action
Then
because
take
of,
action.
because FIR doesn't disclose any cognizable
That's
offense.
why FIR is not yet registered till now.
Yes.
It's not been registered till
Yes.
now. That is why you're just simply summoning or even issued a summon so that you can appear at, then police can talk about it, what is the matter actually. That's why they're not registering any case till now. Because of extramarital affairs, yes, the other sections may be attended, but for that, they are not entertaining the FIR. And at that point, they have not registered the case till now, in any others, in any sections of law. That is the minimum. Third, you are MS.
L. Lumber,
And Lombin, run counsel for the petitioner, and also this is a criminal petition.
Lordship,
Yes,
there's a criminal
Lordship,
petition,
criminal
Lordship.
petition for quashing.
Lordship, Lordship.
Because Lordship, they have given FIR number.
No, what to quash?
Lordship.
Yes,
It should not be
exactly.
registered also.
Because,
Nothing
my-
has been
They
yes,
could, they could,
My, yes,
Lordship,
Lordship.
they could come
Lordship,
for the
my
Lordship.
humble-
Lordship,
Lordship-
not, they could come, Lordship, if they have registered, they could come for the Lordship, AB Lordship, like that Lordship. But then.
Because
no
AB also
registered
doesn't
Lordship.
attract, Lordship. Lordship may kindly consider that because FIR doesn't
If
disclose
apprehension
any
is
of.
there, Lordship, then or because
Because
apprehension is there, then AB is there, Lordship. They can come under Lordship, AB Lordship.
I told you
Yes,
that we-
That's why, Lordship.
Yes, Lordship, even they cannot initiate this summon also, Lordship. They cannot.
We cannot quash the FIR. There's no FIR at all. How can we quash? What, FIR is not yet registered, nothing is there, what to quash?
So, but the Lordship, they have, they have given the FIR number, Lordship.
There is no intimidation against you.
Yes.
FIR is not yet registered. It was an FIR filed by someone, that much only.
Yes,
You come, at the
yes,
appropriate
my
stage, you
submission
can
is
come.
that they cannot even
You
summon
can
me.
come at the appropriate stage if you have any information that FIR has already been lodged. If FIR has already been registered, then you can come with a petition for quashing. But now at this stage, there is nothing to quash. What to quash?
Now, Lordship, my humble submission is that
MS
they cannot even summon me in such a
That is
case.
their part. That is their part. They can summon or not, that is their part, but I cannot quash it. There's nothing to quash. What to quash? It's not against, there is no incrimination against you. There is no FIR laws against you. Simple intimation was given to the concerned police station, that much only. That cannot be set aside or quashed. Rather, yes, as she suggested, you can come up with a petition.
For 39 Lordship, yes.
Or an interceptory. In that case, we can seek instruction whether that has been registered or not, or yet to be, whether there's an initiation. In that case, there may be some, but here we don't have that. You can come with a petition for AB. That may be the other way it can help you, or we can take instruction from the the police council, police station also, that whether this case has already initiated, FIR has been registered, or what is the stage of the case. That has to be, that can be, instruction can be, obtained from the police station. But here now, no, nothing cases. Hard MSL Longi Delaney counsel for the petitioner and also hard MSL Hagi Delaney additional BP appearing on behalf of state respondent. This is a petition on the section 482 CRPC. 482 CRPC for washing. Washing and satisfying that SPA.
Yes, SEPA PS case 06/2023.
23. Also, breakthrough.
Is there the summary, Lordship?
To stay the investigation in SPA, in a SPA PS 06/2023. But on the result of the FIR, so-called FIR, it is seen that the FIR is not yet ready. I know initiation of investigation is commenced as the FIR is not yet registered under any section of law. More so, only a summons was issued to the present informant, present petitioner to make an inquiry within the police station. So at this stage, I do not find any, I find that the present petition is a premature one and is not maintainable in the present form. Accordingly, the same stands dismissed. And however, the petitioner may approach the court with proper application, with an appropriate application. This is disposed of.
Much obliged, Lordship.
Yes, madam.
So this is the 498A.
Yes, ma'am. For quashing of FIR and complaint, my lord.
Both the petitioners are the
Husband and wife.
husband and wife and the informant and the victim.
Yes. And matter has been settled
What is
between.
the stage of the case at this stage? Have you received?
Which-
Case has already been charged sheeted?
Yes, my lord. And pending before the honorable learned CGM
At what stage?
at the PWH. ma'am.
It is an evidence stage.
Yes, evidence. stage.
So there is a settlement between the parties amicably.
Yes, ma'am.
Where they have submitted the
Settlement agreement, my lord.
settlement agreement.
Yes, on the last page, madam, of the petition.
So case was registered on in which year?
2021, ma'am.
21.
Yes,
After long 2 years only the settlement was there.
Yes, ma'am. Actually, they have been married, had been married for more than 30 years, madam. And having son of 28 years and daughter of 24 years. ma'am. And only on the mere on the single incident, my lord, this domestic violence cases has been filed, my lord. If we read the content of
But
the, my
there
lord.
are some photographs, I think, na?
Yes,
He
photographs.
sustained some head injury also.
Yes,
He sustained head injury.
in medical report, it's simple injury. ma'am.
I guess it can.
Yes,
be-
simple is maybe obvious.
Well, I am
Yeah.
talking that.
Yes, ma'am.
Yes, Mr. Ate.
Your lordship, if the settlement matters comes, especially 498 and 323, the Lakshmi Narayan case comes, your lordship. So when,
Squarely covers the. matter.
yes,
Yes.
it's fairly covered. And when they have settled the matter and leaving, your lordship, this maintaining this cordial relationship, then I will leave it to your lordship discretion. Because 498 and 323, your lordship, simple injury. Your lordship.
Your petition will be allowed and quashed.
Yes, ma'am. Much obliged.
Thank you.
Obliged.
Okay. Yes, see. one. Item number one, Apo Mato. You are on item number one? One? Acha, the transfer petition?
Lordship,
Okay. Yes.
Lordship, in this item, I am for the petitioner and Lordship, we may allow to withdraw this transfer petition,
You want to withdraw this one?
Lordship.
Your good name?
J Saro.
Huh?
It's J Saro. J
J.
Saro.
It's his name, your name. is
My
not-
name is not flagged in the cost list. I'm
Hard
on,
so and so applicable on behalf of the petitioner side, and it is submitted that there is instruction from his client to withdraw the present petition. Accordingly, he paid to withdraw the same part. They are allowed. The petition is accordingly disposed of and withdrawn. Okay, it will be withdrawn.
much obliged.
So we have received the LCR also.
Yeah, Lordship.
You want to argue the matter, or it can be simply admitted?
It can be argued, Lordship. We are prepared, I believe. Lordship.
As per office note, number 6, affidavit in opposition has been filed by the respondent number 2. And affidavit in opposition has been filed by the respondent number 2.
Okay.
And we have not been permitted to take copy. I have not been permitted to take copy. Affidavit in opposition.
The private respondent, I believe.
I'm proceed. And we have not been permitted to take copy.
You want a copy?
Yes.
Who is respondent number 2? You are.
Yes. I wasn't aware that I had to give a copy to the co-respondent.
Is it necessary to?
Yes, if there is a petition for quashing. If there is petition in opposition.
No, you are also one of the respondents, so you are very well authorized to make any objection, or affidavit in opposition can be filed by you also, whatever.
Yeah.
But co-respondent, copy of the co-respondent.
No, it's okay. I don't mind.
If
I
you
mean,
can
I don't
provide,
mind
you
giving.
can provide.
My lord, one thing can be considered that we had annexed the complaint petition in our main petition. The affidavit in opposition is a reproduction of the same only, the complaint
No, no,
petition.
no, they have filed.
They have filed.
Ah,
It is the
yes,
same
number
reproduction. Yes, respondent code. So what they had filed before the learned CGM Alok, the same has been reproduced as an affidavit in opposition. So we had annexed the complaint. I'm just suggesting, you know, that we had.
In that case, your lordship, can it be taken up on Monday? I'll be giving today. I mean, we are all for disclosure.
I'm for your is there no?
Otherwise, this is a case of which nature? If otherwise, section.
It is forgery, Lordship. Forgery and
Forgery.
420. Yes.
So government is necessary.
Yes.
Government is a necessary part. I
Yes.
thought the 490 was something that will be private nature, otherwise you are necessary. If it is case of forgery. Otherwise, we have received the LCR, so list on Monday.
Lordship, a small prayer, Lordship. If it could be on the 2nd or 1st, Lordship.
2nd of August.
August, 1st or 2nd.
Yes, as per you,
Second.
will it be possible on 1st or 2nd of August?
2nd of August.
1st of August.
1st of August.
Yes.
Will be okay, or 2nd of August?
1st of August. Second, I'm a bit preoccupied, lordship.
Lordship, actually, I would be out of station. Maybe that's why. 2nd. First of August.
You will be here on 1st of August or not?
Lordship, there may be some difficulty on my part. That's why I was suggesting 2nd of August. Lordship.
Okay, then now we have listing on 1st of August.
Yes, Lordship.
If you have any difficulty, let us see if 2-3 days we can make accommodate.
Yes.
Much
Otherwise, it is in the meantime, I'm not reflecting any order, we just submit the report.
Yes, Lord.
Copy to.
Yes.
So we list on 1st of August. Okay. it will be
Of
listed.
lordship.
Much
Marvelous one.
Yes.
Well, so far this case is concerned, my lord. Initially, when case was admitted, the step was taken. Thereafter, my lord, as part of direction of this honorable court, the second fresh step was taken. Thereafter,
By which mode?
16/8/2022.
No. Under what mode you have taken? By to register for what
Yes.
what mode? To register AD? Or
On my lord, 16/8/2022. Yeah.
16/8.
2020. So
You have taken last on 16/8 only.
last on my lord, 17/22.
Huh?
24 28, 22 August 22, madam.
Once you have taken step on 25th of April 2018 and thereafter,
And though it is not permissible, but I have been permitted to take the state through the dusty, and accordingly the dusty service was also taken. And one thing, my
what
lord,
is the report of the dusty? Have you filed any affidavit
Yes.
in that regard?
my lord, in this
Is it
regard,
served or not?
has not filed, but the record is with me.
We have not filed affidavit.
Yes, madam. And one
Have
thing,
you
my lord,
taken steps through the jurisdictional police station?
Yes, Lordship, there's a concerned police station, Lordship, concerned OC of the.
He has already taken steps.
Lordship, if it has not taken a step to the OC concern, Lordship, then this time it may be taken, Lordship.
my last step was on 3rd April 23.
3rd April 23.
Yes, 3rd April 23.
So this
what
was
it-
also, I think, through registered AD.
Yes,
as per the office
it was through the registered post.
Now, see, the registered AD most probably we are not receiving. So this time, I don't know when it was dusty was allowed to you. But even if dusty is allowed to you, most probably you have not filed the affidavit in that regard. So let us take a fresh steps on response number 2 and 3, this time through concern of OC of the concerned police station.
Ma'am.
That means serve the purpose. Otherwise, it is pending. And the case is of 2018. So at this stage, still it is a stage of appearance. So
Ma'am.
heard Mr.
Steve
Steve
Modi.
Modi, the learned counsel for the petition. I also heard MS and Haki, the learned petition PP, appearing on behalf of this number, state respondent. It refers from the office note that the notice, the registered AD as well as answered notice on the response number 2 and 3 are not yet returned. However, it is, no, you're not yet written, and hence I find it prudent to, and accordingly the petitioner is hereby asked to take fresh steps on response number 2 and 3 to the OC of the concerned police station. Steps may be taken within 7 days as the matter is of 2018 and list accordingly after 4 weeks.
All right.
Okay.
No, respondent. Respondent.
No, yes, I'm for. Police station.
I'm for respondent, private respondent. Yes, Your Honor.
Private person.
Private respondent.
Petitioner is. Completed. Yes, sir. Here it is, CV.
And Your Honor, the petitioner have taken repeated adjournment in this case. Yes, earlier also they have taken. Yes, Your Honor. They have taken adjournment on several occasions.
Yes. Yes.
Yes, that is completed. N Kaku. Much obliged. What is? This is a mistake. This is a mistake in the course, please.
Petitioner here. Two and three. Yes. One is already received. Your Honor, my lord, dusty survey may be allowed.
You have taken dusty service
Yes.
already.
No, I may be allowed to take
Now,
Pardon,
see,
yes.
otherwise it is a criminal matters. Dusty are allowing some matters, but the civil matter generally dusty should not be allowed. So let us do one thing, issue a notice to the concern OC of the concerned police station. That may help you because of this time. Otherwise, we are waited for the service and response number 2 and 3 since long. So it will not work out. So that is why.
Okay.
Card your good name.
My lord, T. Shiva.
Your name is not here.
T. Shiva, actually my,
Naam to nine again. Card Mr. P. Shiva, the learned counsel for the petitioner. It is from the office note dated 25/7/2023. It reveals that the service is still awaited on response number 2 and 3 since long. Accordingly, I find it justified to, and accordingly, I asked the petitioner to take fresh steps through OC of the concerned police station within 7 days from the date of order. Order is still, otherwise you are the filing advocate.
yes.
They have full stop. The registry is further directed to reflect the name of the land council for the petition on the court list in the next date of listing. Let the matter be accordingly listed after 4 weeks. So the registry will be directed to reflect your name in the process.
All right.
Yes, you are on 50.
Yes, Lordship. The office note indicates that the AD card is yet to receive returned. Lordship.
AD already returned.
It has not been returned, Lordship,
It can be-
upon the respondent.
Can it be wait for one more?
Yes,
Huh?
we can wait, Lordship.
Heard Mr. Chital, learned counsel for the petitioner. from the office note dated 25/7/2023, it is seen that AD card and the answer notice is not yet returned to the concerned section. Let the service be awaited till next date.
Your Lordship, there has been some development in the matter, Lordship. There was an interim order.
Interim order was there.
There was an interim order directing the the customary authority not to proceed with the kawam, but they had nevertheless proceeded with the kawam.
Oh,
So that is
then
an
for that you can, you should, I think, file a separate IA.
Yes, Your Lordship, that-
In that case, next week you can file separate IA. And I don't want to list it after 4 weeks. Let it be a list after 3 weeks. In the meantime, we can wait.
Yes.
After 3 weeks. And for that, if there is any violation of order and also you can file an IA.
much of it.
Now, item number 16, this is the hearing matter. Are we-
For the long time, it has been leftover matter. So,
No, we
so
are
many
going to
occasions,
hear, otherwise I'm not, but question is that now it is 12:40, can it be taken at 2 or you can start someone because by 12:45 I'm supposed to rise before, because we have a meeting actually. full board
Just
meeting.
take up the matter.
Just I want to peruse the agenda, so that is the main reasons. 1:15 meeting will start. So that is the reason I want to take it at 2
Okay, no problem.
PM, okay? Otherwise I'm ready.
Yes, okay. I'll let you.
This time it would not be a leftover matter. This time.
Highly obliged.
Several consecutive days. So today they are ready and most probably you have come from
Tejpur.
Tejpur. So that is the reason you want to have hear the matter.
In that case, Lordship, this case is pending for since 2016, Lordship. The case of 2016, and there is financial, some benefits are there. So if interest is default, then also NSPC will be affected, Lordship. That's why the matter is very urgent to take up. And so many consecutive days because I joined.
If that be the case, Your Lordship, the matter will be taken up, Your Lordship, and we'll argue our part on the next day, Your Lordship. Mr. Pangling will place his arguments on the next day. She may continue with her part. If they-
In that case, most probably on the next day also you have to appear because
Then again, that will be the
if
leftover
there
matter.
is any reply, maybe like there may be any reply from their part.
Let it be part her, Lordship, if possible. Let it be part her, the next week.
Part her means
My
you
part,
want to
I.
place your part.
Yes, yes.
But the question is that one more aspect is there. I want to make it any part heard order because part heard, what will happen? If part heard is there, then definitely the matter will be placed before me only. This is the now the. present
Next week,
tense of
your
it.
Lordship will be there, no? Next week?
Next week I'm here, but
That's-
question is that next week must be on Tuesday and Thursday, na? In which date we have fixed it that criminal appeal, criminal appeal. It will take some time. It was fixed on most probably on 3rd of August or 1st of August. 1st of August. 1st of August, we have fixed one date on the hearing day, that is on Tuesday. It will take some time, so I cannot accommodate most probably on the 1st. So
No, if my part is-
if it can be accommodated on 3rd is Thursday, 3rd is also hearing day on that.
Lordship is, if my part is hard today and tomorrow their part is hard, that will be a difficulty.
That you may be some way or the family, you may be because from your side, the
We have very
reply,
limited player with 2 points on them. Very limited player, Lordship.
tomorrow I cannot say tomorrow because it's Friday, I cannot say we have some.
Then any day next week, their part can be hard.
So you are ready to note it down from her submission. You
Ma-
can,
Nowadays, this
My lord,
measure-
it would have been proper had the full hearing had been taken up, Your Lordship. However, if they have any difficulty, then it can be taken up as a part. of the-
as per you from your side,
Lordship,
what
nowadays
will be
this
the time taken by you from your side? Say half an hour, one.
15 to 20 minutes,
15
not more than that.
Not more.
I'm only on 2 points and I'm not going to dispute all the issues and everything, nothing.
Only 2 issues.
Only 2 issue I have.
Yes, what you have said. You can very well note down those
Yeah,
two
yeah.
issues.
We have
here.
no problem in that, Your Lordship. If that be so, then she may continue with her part and we'll take our part on the next.
Tomorrow it may not be possible, most probably it may be fixed on Thursday. Thursday, if you have any means to come, or if you any other works in here,
No,
then
I
you
don't
can,
have-
you
see,
can be
actually-
very well present on the Thursday also. Thursday, in a sense, I'm going to hear you today. It may, the matter may be listed as a partner matter, so it will be listed before me, because since till next week I'm here. That will be no issue. But question is for your benefit or for your convenience, I'm saying that if yeah, after hearing in your part will be, matter will be kept as a partner today. If you can be.
My juniors are there, she can be.
She can.
She
be
will.
there. No, if
Even
any
if I'm not-
reply is to be there, that's what I'm saying.
She can do that.
Okay,
Another-
okay, and then it's. So we can hear her, you just remain present.
Yes, Your Lordship.
No, let's.
Thursday or first?
Third, it was on
It's
third, I
actually-
think.
2 p.m. 30 and 32, they will fix on.
Third,
Third.
yes.
Oh. In that case, your matter will be fixed on Tuesday, next
First.
Tuesday, okay. 1st of August.
May I please, Your Lordship?
Yes.
Lordship, I have preferred an appeal on behalf of NHPC Lordship. And I have, under sections 96 of Code of Criminal Procedural Lordship,
Hmm.
being aggrieved by the judgmental order passed by the additional district and session court, Basa Lordship.
Hmm.
On 31st May 2015, Lordship. Lordship, the fact of the case is this, Lordship. The respondent in the present appeal filed the civil suit stating that the respondent defendants 3, 4, and 5 in the present appeal placed an order for supplying 4,000 bags of cement at the rate of rupees 212 per bags plus cartridge at the rate of rupees 80 paisa per quintal, and also requested him to deploy minimum 4 trucks for carrying the said quantity of cement to the store, that is at Kamba Balak store site, white letter dated 9/7/2003. Lordship, here I'm reading my petition application, page number 4. The facts of the case, Lordship. And the appeal petition,
Page number 4, your petition.
page number 4, it's my petition. Now, Lordship, the respondent defendants. Page number 4, Lordship.
Yes.
Point 2, the respondent defendants assured the respondent plaintiff that the plaintiff shall be made within 20, payment shall be made within 20 days after receipt of the material at the site. In the plaint, it has also been stated by the respondent plaintiff, that is NSPC, assured him that in case the respondent defendant do not make the payment, NSPC will make the concerned payment. It has also been stated in the plaint that the respondent defendant again by letter dated 26/7/2003 placed an order for supply of 10,000 bags of cement for the civil works of Kambang HC project on being supply of 4,160 bags of cement, that is 208 mg. The respondent plaintiff submitted bill dated 23/7/2003 for an amount of rupees 11,18,874 for cement at the rate of 212 per bag and transportation charges 80 paisa per quintal from Likhavali to Kambang. After supply of 1,380 bags of cement, that is 69 MT, the plaintiff submitted another bill dated 4/8/2023 for an amount of rupees 3,71,165 per bag. That is rupees 212 with Arunachal Pradesh sale tax 8% and the transportation charges. This is, I'm reading the sum up of the plaint filed by the defendant. Lordship, here, according to the plaintiff, respondent defendant handed over a check of rupees 1 lakh only with reference to letter dated 9/7/2003, and for further payment, Mr. Jitendra Singh, project manager for Prem Power Construction Private Limited, said a letter dated this to the respondent plaintiff requesting them to submit the treasury challan along with the concerned bill to enable the release of payment. The respondent plaintiff complied with the said letter and furnished the requisite documents, and a copy of the letter sent to Messrs. Prem Power Construction was also endorsed to NHBC, but Messrs. Prem Power Construction did not make the payment, despite reminders by the respondent plaintiff and also letters written by the NHBC. This is the case filed by MS Enterprise, who is the subcontractor of PPCL, Prem Power Construction. Now, Lordship, NHBC has got the contract from Government of Arunachal Pradesh, and they have executed a agreement with PPCL for completion of the work. Now, as per their contract clause, there is no such clause that this contractor, PPCL, can engage another contractor for completion of the work. So as per their contract clause, which is in page number 35, Lordship, page number 35. This contract agreement is executed between NHBC and PPCL. Here, Lordship, the contractor shall not sublet, transfer, or assign the whole or any part of the work under the contract. So there is a provision that he cannot do so. But without the knowledge of NHBC, he has engaged MS Enterprise. And MS Enterprise is not a party to the agreement. So there is a violation of privity of contract, etc. As per the privity of contract, Lordship, the doctrine of privity of contract is a common law principle which provides that a contract cannot confer rights or impose obligations upon any person who is not a party to the contract. The promise is that only parties to contracts should be able to sue to enforce their rights or claim damages or such. So as such, in the lower court, in the court, the additional district and session court, MS Enterprise has wrongly made us a party, because we have nothing to do with the contract work which has been done by him. We received the goods and we have executed the work. PPCL has executed work. And as and when PPCL has given bills, NHBC has cleared all the dues. And the work is also finished now. Now what happened, Lordship? The court below has examined 5 witnesses. 5 witnesses, and each and every witness has mentioned that there was a verbal commitment by the officer of the NHBC for payment of the bill. No written letter, nothing can be shown as such. Only they are saying that work has been done and there was a verbal commitment by the officers. But there was no sufficient document, any document to show in writing that NHBC is liable for any payment to Messrs. MS Enterprise. Because he is not a contractor. Our contractor is PPCL, and we have already paid him as far as he has submitted the bill, and accordingly we have paid him. Now, Lordship, as and when
your work was done by under whom? Who was under
Prem Power Construction?
Prem Power Construction.
We have executed agreement with them. Prem Power Construction. Here, Lordship, they have made party here. Defendant number 5, 6, and 7. Prem Power Construction. MS Enterprise, in their money suit, they have made us party 1, 2, 3, 4, defendant number 1, 2, 3, 4, and Prem Power Construction 5, 6, 7. MS Enterprise has made. Whereas we are not concerned with MS Enterprise, the plaintiff in the money suit, because he is not a party to our agreement. But as and when he has given any letter to PPCL for his payment after completion of the work or during the executing the work, we on good faith have written several letters to PPCL that you clear all the dues. Those letters are annexed, but we have given only assurance that when we have got the work done, materials have been given to us. So we have made payment to you, PPCL, and PPCL, we have instructed, given letters to PPCL that kindly pay Mrs. MS Enterprise if you have engaged as him as a contractor. But we are not directly given any, we have not directly given any letter to MS Enterprise. This is the only our method that he is not a contractor. We are not supposed for any payment. We have been wrongly implemented in this case in the money suit, and the lower court, the additional district and session court, has, without using his judicious mind, has passed an order on 31st. Lordship, may I read that order, Lordship? Order is in page number 125 in the paper book, Lordship. In the paper book, Lordship. Should I read the judgment or the decree, or you will go?
135.
The order is in 145, page number 145, the order. What is it?
Yes.
So 9 issues were framed, and we have been, we were in 3 issues. Other issues are related to MS Enterprise and PPCL. We have nothing to do with that issues. Now, the order is passed, Lordship, may kindly see. From the discussion made above, it is clear that the plaintiff made the supply. But the main question is, who is to make payment for the same? It is not denied that the PPCL made the demands as supported by documentary evidence. From the records, it is also revealed that in failure of the PPCL to make the payment, the NHPCL could make the payment of the plaintiff by the running account bill, provided that PPCL gave full consent to the defendant, no one else. But PPCL has never given any consent for payment to MS Enterprise. Neither MS Enterprise is a party to the agreement. We don't know any MS Enterprise. NHPC does not know MS Enterprise. Somebody is dropping the goods, and we have executing the work. Work is executed by PPCL, and NHPC is giving the bill payment as and when bills are provided to them. Now, in the premises as discussed above, this court hereby directs the direction of the Honorable Court, the defendants jointly and severally to pay the plaintiffs an amount of rupees 13,90,039 only, with 6% interest per annum on it, with effect from 11/11/2004 till date of realization of the amount. The defendants are further directed to pay an amount of rupees 30,000 as cost of this suit, and the whole amount should be paid to the plaintiff within 90 days from the receipt of this order. The defendant number 1 and 4 is further directed to make payment from the PPCL. There is no bill pending as such. As and when the work is completed, PPCL, we have made all the payments to PPCL. Now, Lordship, we have also given in the lower court, Lordship, we have also made an written argument also we have filed, that there also we have specifically mentioned all things, narrated all the things. Lordship, it is in page number 115, Lordship. Kindly see the written 115, 115.
This is
What is, Lordship? Right?
Yes, yes.
Written argument submitted on behalf of the defendant number, respondent number 1, 2, 3, and 4. Here also, Lordship, we have specifically stated, Lordship, may I read, Lordship, that instance money suit was filed before the Court of Deputy Commissioner, West Siang District, Allo, Arunachal Pradesh, by the plaintiffs, and same has been transferred to this Honorable Court, accordingly registered at BSR MS number 68/4, that the defendants number 1, 2, 3, and 4, that is NHPCL Limited, was the contractor of the Khambang 3x2 MV small hydroelectric project, Arunachal Pradesh, and after taking the contract work from the government of Arunachal Pradesh, the civil construction work was awarded to defendant number 5, 6, and 7. That is Mrs. PPCL Company Limited as a subcontractor of NHPC. NHPC is a contractor, this is a subcontractor. That as per the MOU executed in between defendants, the civil construction work was carried out by the defendant number 5, 6, and 7, and accordingly payment was made to them. as per the progress of the construction work. And it is pertinent to mention herein that the defendant number 1, 2, 3, and 4 never and ever entered any contract agreement with the plaintiff number 2, who is the attorney holder of plaintiff number 1, for supply of the cements. That for the supply of the cement, agreement deed was made in between plaintiff with the defendant number 5, 6, and 7, that is PPCL Company Authority only, but not with the defendant number 1, 2, 3, and 4. And as such, defendants number 1, 2, 3, and 4 are not having any responsibility for payment, non-payment of cement supply dues of plaintiffs. And it is further argued that the defendant number 1, 2, 3, and 4 has been wrongly pleaded, made as a party to instance money suit. That the plaintiffs has made defendant number 1, 2, 3, and 4 as a party in the instance money suit, alleging that Chief Engineer NSPC Khambang Alo has made verbal assurance. It is verbal assurance to pay cement supply bill on behalf of the defendant number 5, 6, and 7, but same has been denied by the NSPC authority. And it is a fact that as and when defendants 1 to 4, that is NSPC authority, received letter from any side about the dues of PPCL, that is defendant number 5, 6, and 7, with the plaintiff, same has been again informed to the PPCL authority for payment of the dues. That the defendant number 1, 2, 3, and 4 cannot pay dues to plaintiffs without the consent or the direction of the defendant number 5, 6, and 7. They have not given us any direction for payment to the MS Enterprise, so we have not paid anything to MS Enterprise, and MS Enterprise is not a contractor to us. Is the subcontractor of the defendant number 1, 2, and 3, but the plaintiffs has got no any relation connection with the defendant number 1, 2, 3, and 4, that is NSPC authorities. Plaintiff have no connection with NSPC. That after hearing all the parties, counsels, and also considering the claims and counterclaims of the parties, as many as 12 issues and 3 admitted facts of the defendant number 5 and 6 has been framed. Out of these 12 issues, Lordship, only 3 issues admitted facts are 2, that during trial proceedings of the case has examined as many as 5 witnesses. Now, issues, what are the issues, Lordship? Should I read the issues, Lordship?
What are the main issues you are stretching on?
Number 5, whether the defendant one, number 5, 2 are admitted. 1, 2, 3, 4. Just a minute, Lordship. Issues number 5, 9, and 10. Which Lordship will find in page number 123, Lordship. Now, taking into the issues number 5, 9, and 10, we should take the summary of statement of all the witnesses. Here in the instance money suit, plaintiff advocate tried to mislead the court by exhibiting the letter written to defendant number 5, 6, and 7. We does not deny the fact that we have not written any letter to PPCL. As and when MS Enterprise has complained that they have not received any bill, we have immediately written letter to PPCL for immediate payment of the dues of MS Enterprise. And surprisingly, PPCL has not appeared in this appeal case. Though we have made him party, they have not turned up in this case. So, and all the letter given to PPCL by NSPC authority was at request of the plaintiff only, and on good faith, the NSPC authority written letter for plaintiff to PPCL authority, and as per work agreement deed in between NSPC and PPCL without the consent of the defendants number 5 and 6, the NSPC authority cannot pay release bill in the name of PPCL in favor of any party. That as and when defendant number 1, 2, 3, and 4 gave letters to defendant number 5, 6, and 7 for plaintiff, sought consent of the PPCL authority, but they never give consent, and without the consent of the PPCL, the NSPC, that is defendant number 1, 2, 3, 4, cannot pay bill to anyone on behalf of the PPCL authority. So, Lordship, this is the case. This is the case in brief. MS Enterprise is not a party to the agreement which we have executed with PPCL, and PPCL has not turned up here in this appeal petition. And Lordship, as per the privity of contract,
stand of PPCL there in the original suit.
They have admitted that much of bill that is also there, Lordship. Lordship, they have filed one written statement, PPCL.
They have filed a separate written statement.
No, it's there. PPCL. Yes. Page number 65, Lordship.
65 of.
65 of paper book. This is their written statement. Page number 65, Lordship. Got it, Lordship? Here, Lordship, should I read it, Lordship? That the above caption doesn't. Lordship?
And what was the main plea that was I want?
They have has no privity of contract with either of the answering defendant, the plaintiff. They have just to deny the contract clause and privity of contract between either of the plaintiffs and defendant number 6 and 7, defendant number 9. They have not taken any specific ground, only denying the allegation only. They have paid, as per their version, they have paid. And moreover, they have questioned the power of attorney holder also. There are certain disputes regarding the bill also. It's not on your lordship. Now, my prayer to this honorable court is just to set aside and quash the judgment or order passed by the district and session court. On 31st.
See, you are for the
30th
different
of
number
July.
1, 2, 3, and 4. And PPC or they are mostly different number originally. They were the different number 5, 6, and
7.
5, 6, and 7. Against the order of the learned court below, they are not agreeable.
They have
So
not
you-
challenged
you're-
us.
You're challenging the order.
I am
with
challenging
respect
the
of the
NSPC.
order direction passed against you
Yeah.
for the payment.
Yes.
That much.
That much. And PPCL has never approached the honorable court. They have not filed any appeal also. Moreover, they have, I heard that they have filed some arbitration case against NHPC. Yes, ma'am. My humble prayer to this honorable court to set aside and quash the judgment order passed by the additional district and session court on 31st May 2015. Because we are not liable for any people. Yes. And moreover, I have submitted to judgment also, Lordship. That is also they already given there.
Here. One
Yes.
is here, right? Yes, yes.
Two judgment.
2 are here. One
One
from Himachal,
Chaco,
one from Himachal Pradesh,
Himachal Pradesh,
and one from.
one from MC Chaco, Lordship. The well-known judgment,
Yes, yes.
MC Chaco. When he is not a
Stretching on
party.
Para.
Para 2, Lordship. In the second page, Lordship, MC Chaco. Even if it is granted that there was an intention to create a charge, the creditor bank not being here, the party's bank, not being a party to the deed, could not enforce its covenants. It must be taken as well settled that except in the case of a beneficiary under the trust created by a contract or in the case of a family arrangement, the right may be enforced. So they are not a party to the agreement made by NSPC and PPCA. And Lordship will file page number 5 also, Lordship, the relevant paragraph. The Proton Bank, not being a party to the deal, was not bound by the covenant in the deed, nor would it enforce the covenants. It is settled law that a person not a party to a contract cannot, subject to certain well-organized exceptions, enforce the terms of the contract. The organized exceptions are that beneficiaries under the terms of the contract or where the contract is a part of the family arrangement may enforce the contract. This is also very relevant. And in the last paragraph, Lordship, page number 6, even if it is be granted that there was an intention to create a child, the Proton Bank not being a party to the deed, same thing is repeatedly written. And last paragraph, having regard to the circumstances of the case and especially that a concession that persons not parties to a contract may enforce the benefit reserved to them under the contract was made before the High Court, we direct that the parties to this appeal will bear their respective costs for, and the case was dismissed. And in the Himachal Pradesh case also, Lordship, same regarding privity of parties. The relevant portion I have found in page para 17, Lordship, page 4. The doctrine of privity of contract implies a mutuality at will and is interaction of parties and their successor. It creates a legal bond or tie or vinculum juris personalis to the parties. The rule thus is that no one except the parties to a contract can be bound by or entitled under a contract. This doctrine, which requires third party to enforce a contract, forbids the parties to the contract from enforcing any obligation thereunder against a stranger. So MS Contractors is a stranger for us, Lordship. And in para 19, two of the exceptions of the general rule that a stranger cannot enforce a contract, as ruled by the Honorable Supreme Court in the case Supra, are the beneficiaries under the trust created by a contract, or in the case of a family arrangement. The same thing is repeatedly written. The above view is further supported the ratio in case Kedar Das Mohta and Nandlal Poddar, AIR 1971 Patna 253. It has been held therein that an agreement cannot be enforced to the instance of a person who himself is not bound by it. So mainly I am on this point only, that it reflects privity of contract, and as because MS Enterprise is not a party to the contract, so we are not liable for any payment. And as such, the order passed, judgment and order passed by the Honorable Additional District and Session Court on 31st May 2015 may set aside and question.
Take it part. MS. You good name, MS?
S. Nag, Suparna Nag,
S. Nag.
NAG Nag.
Also. It is requested on behalf of Opara that he is not in position to argue the matter, and hence matter will be deemed as a partner. List accordingly on Tuesday will be 1st of August. On 1st of August.
Okay, if I can, I will stay back, Lordship.
Tezpur it takes around 3.5 hours.
3.5 hours only, but I stay here, Lordship. I have one rented house here.
Oh, here you're staying.
But my family shifted, that's why I keep on going and.
Otherwise, you practice in Tezpur, but
yes.
We were there in Tezpur for about more than 3 years. I was posted as a CGM there. I'm from Judicial Service. So Tezpur, we find a very nice place. Very nice place to stay.
Yes. Nice photos. I started my practice from there. From there, Tezpur.
Tezpur.
My mother's house is also in Tezpur.
Okay.
Here.